jury. We're going to take up the motions in limine, but before we do that, I understand Mr. Gibson has a matter for the court.
Yes, Your Honor. We had a long time ago filed a motion for change of venue. It was deferred until we tried to pick a jury. We renewed that at the start of jury selection in this case, and we made also a motion for individual voir dire. All of those motions were denied. We did our best to select a jury under the procedure that was required in a manner that would not taint who was left on the jury. We still believe that motion for change of venue is appropriate and used all of our peremptory challenges in this matter that could be used on people that were actually seated as jurors as opposed to alternates. And so we would renew our motion for change of venue at this time.
Okay. Thank you, Mr. Lee. I understand Mr. Gibson is renewing his motion. Does any other defendant wish to join the renewed motion for change of venue?
I do not wish to join, Your Honor.
Thank you, Mr.
That particular motion, only that one.
Mr. Schmaltz, do you join?
No, Judge.
Very well. Does the state wish to be heard on Mr. Gibson's renewed motion?
Just briefly for the record, Your Honor. Having gone through the process and looking at my notes, it's my understanding that of our 14 jurors that have now been impaneled and that apparently will be contacted and will show up for court, only one of those was a juror that defense counsel had moved to have excused for cause. That motion was denied, and then they did not choose to exercise a peremptory, obviously, because that person's on the panel. That's what my notes show, so I just wanted to make that record, and the state would again ask the court to deny the motion.
Thank you, Mr. Kalbaugh. I'm satisfied that the jury has selected that each of those jurors can try this case impartially and without substantial prejudice to any of Mr. Gibson's rights. I believe the jury is appropriately unbiased and fair and impartial. For that reason, I deny Mr. Gibson's renewed motion for change of venue. Anything else on that subject?
Okay. No, Your Honor, thank you.
That being so, we'll go back to our list of motions in limine. I think we were up to 45. Mr. Gibson's. I thought we had done 45.
We did.
Yeah, I think
45 was granted.
Oh. It was reminding me that I have a list which I should refer to. 45 granted is unopposed. Mr. Gibson's motion limine 46 seeks to prevent the introduction of testimony from Detective Trainer relating to statements from people who were charged in this case and resolved their case with a guilty plea, to prevent Detective Trainer from relaying statements made by those former co-defendants to the detective.
We concede that motion?
That motion is appropriate, it is granted, and it is unopposed.
And just to speed things along, same with 47, which I think we've pretty much, there's already a ruling that I think already captures this.
Just for the record, 47 is a motion to prevent the introduction of testimony through Detective Trainer about any conclusions that he has come to on any topic, having reviewed the videos. I agree. I think that is covered by a previous motion, but as it is unopposed, that motion will be granted as well, even if it is to some extent or entirely redundant to earlier rulings in this matter.
And I don't think this is likely to come up at all, but with respect, going back to 46, I don't know that there would even be a way to open the door, but should there be some way to open the door to that by inquiring about other people having been charged or something like that?
The state has leave to return to the issue if it believes the door has been opened, although I'm having trouble envisioning that scenario.
But we would always approach the court first, of course.
Certainly. Motion 48 seeks to prevent the introduction of testimony through Detective Trainer that the injury sustained by a Cider Riot patron was the result of Christopher Ponte throwing an object into the crowd at the bar.
That is also conceded, no problem.
Your Honor, could you repeat that?
Mr. Doyle, certainly. It is to preclude testimony from Detective Trainer that an injury sustained by a Cider Riot patron was the result of Christopher Ponte throwing an object into the crowded bar.
Thank you.
Ponte.
Ponte, thank you.
Ponte.
I'm fairly familiar with mispronunciations of French-derived surnames. Motion number 49 from Mr. Gibson seeks to prohibit the introduction of exhibits prepared by Detective Trainer that have not been provided on the exhibit list. Does the state anticipate to offer any exhibits other than those on the exhibit list?
We don't, of course, with the caveat that if something changed that we didn't anticipate, that we wanted to introduce a new exhibit, we would approach the court to do that. The only other thing I wanted to
Let me just make the record on that, which is 49 is granted then, and I understand it is unopposed, understanding that a party has leave should something come to show the court appropriate cause for why they should be allowed to do so.
And just responding sort of to the second part of this paragraph, we're not going to introduce any screenshots that have, captions or writing or arrows or anything like that. I think we probably will certainly generate screenshots from like still images of video that has been admitted.
Okay, and I didn't understand that. Well,
Your Honor, the issue is that in the discovery, the detective had taken screenshots from videos and then overlaid commentary on top of them.
no objection to the stills in their relatively native form, just a paused image from the
The
video.
video exhibit is in the record and they want to freeze it there or screenshot it there, that's an exhibit.
Okay, I think we're all on the same page then.
Yeah.
And we might put our own arrows and whatever in a closing argument, but that would be completely different.
Okay. Juror number 50 seeks to preclude testimony through Detective Trainer that I think is a suggestion that there was a rule at Cider Riot that patrons could not drink in the inside area if they were wearing a mask or a helmet.
Yes.
Okay.
That came out in the grand jury testimony.
That was just a rule that establishment enforced or put.
There was some kind of a rule that was discussed. I don't know if it was a law or what, but they couldn't maintain their mask status while going inside.
Okay. And you're looking to preclude evidence that there was such a rule?
Yeah.
Okay.
There's not an objection subject to the door being opened somehow.
Okay. Subject to door opening, at which point the state will advise the court. Granted, motion number 50 is granted and unopposed. Motion number 51 is a discovery motion relating to Frederick Saup.
Yes, Your Honor. And I would have brought this discovery motion sooner had I knew that, just for the court's background, I think it's Sapi. He was put on a witness list for us, I think last week. And that's the first notice we had. He would be an actual witness, checked his Twitter account. And that's when we saw this and immediately requested it. I don't know if there is any more, but.
Okay.
Yeah.
Okay.
From my perspective, this really hinges on whether there's anything in the state's possession, custody, or control.
I agree.
Yeah, we have put everything that we have in discovery. If he's been writing stuff or posting stuff.
Okay. The state is not in possession of any of this potential witness's writings that it has not produced.
That's a more artful way of saying that.
Okay.
Your Honor, I could be mistaken about Oregon law, but at least the Washington practice and rule is that if he has material, a third party has material that would be discoverable, and he said he did a writing, prosecution has an obligation to request it if we ask them to. And what he says in there is he's going to do a writing about what he saw.
Can you point to statutory authority for that?
It's jammed.
Mr. Buchal, I am
You can
potentially
pause on this one and come back to it if you want to, if you need a couple minutes.
Go by.
Yeah, we'll come back to that, Mr.
That's fine. Is this witness under subpoena?
Yes, Judge.
Okay, is it a subpoena that merely goes to trial appearance and testimony? It doesn't require anything else?
From the state, it is, yes.
Yes. Okay.
Yeah,
We'll
I don't
pause
know.
there, we'll come back.
Have you guys subpoenaed him? I don't know.
I did not.
No. No
They've
subpoena.
subpoenaed there's some cross subpoenas, so I wasn't sure
Okay.
if they had any.
But the state subpoena does not request any production of things.
Correct.
Okay. Motion number 52 seeks to prohibit the introduction into evidence of a particular video under OEC 402 and 403.
Yeah, the little background on that, Your Honor.
Yeah.
The way the video was originally captured was it was pulled by screen capture off of YouTube instead of primary source downloaded. And so you had things, and you're going to see some of these following motions, pop-ups that are now part of the video.
Because it was, when it was recorded, it was with, okay.
Right, so the video is playing, and then a pop-up comes over, but they're screen capturing both. So if
Okay.
you
And is it a pop-up in the sense that I think it is, where it's just a text bubble coming up?
It's bigger than that. So
Okay.
if you look down into the next page, I have a screenshot
Oh,
of
okay.
it for you.
Perfect.
And it says pretty clearly, high-risk level 3 wanted sex offender, right in the middle of the exhibit. That's kind of hurtful.
Okay.
And really got nothing to do with the case. And then you scroll down further, and it's got an editorial title, Patriot Prayer, and Proud Boys at Cider Riot. Proud Boys were not there, and so
Okay.
those are the issues.
Okay.
Trimming the editorial title, I agree, is appropriate, very easy to do.
Okay, so that I think means that motion 53 is granted and unopposed, and the state will be ordered to do that trimming before the video is played. So now returning to 52.
That's just the like border caption. All the substance of the video can still be captured without the
Subject to
title.
the hearing and stuff we will have tomorrow, Judge, in case there may be other issues they had.
Oh, sure. Right. But if the video is received into evidence, it must be without that bottom text.
And then there's no problem with figuring out a way to exclude the bulletin pop-up. You don't happen to have a timestamp written down for where that?
I got it.
I mean, not that, yeah.
Well, on the
You can move on.
53, you can see from the red bar that it's, and the timestamp is 2536. Or, yeah, 2536.
Okay.
But it's the earlier one that you really need the timestamp for.
Yeah, 52 is the one.
I think that is also towards the end, if that helps, but it's pretty conspicuous.
Am I right that that Mr. Gibson would be satisfied if there was a black box put over it instead of that obliterated the text?
The second issue, Your Honor, which is that whatever device they're using that encodes the entire screen rather than just the video is making the video files bigger and very difficult to jump around in. If they just download the source, then if you play it up on the screen, you get the whole thing and not the little one that's inside the box. And so if there's a way to do that, that's the best way to handle it.
Okay, let me encourage the parties to talk about that.
And Judge, I can put on the record and thank Mr. Buchal for providing a different version of a different video we had that apparently satisfied the issues he's talking about. And if he wants to help us do that, and he has a different version of the video we intend to offer, we're happy to talk about whatever, for any of the videos we intend. If folks want to talk about a better version, we're happy.
Okay. That notwithstanding, 52 and 53 are granted. The state needs to remove or otherwise obliterate the offending text.
Does the court want to go back to?
If you're ready for 51, we can go back.
Yes. And by ready, what I mean to say is that the Oregon law on the rules of discovery and obligations of the prosecutor is constitutionally deficient. And it's not as advanced as northern states such as Washington. And in the great state of Washington, the prosecutors have that obligation. And I'm making an argument that the law in Oregon should be extended to provide more due process.
And that pursuant to that extension,
Put it on the
Oh, yeah.
He's not allowed to.
Awesome.
and pursuant to that extension, that Mr. Gibson is entitled
Yes,
to this writing if it exists.
yes, sure.
Okay, thank you.
Our position is that we are following Oregon law that is not constitutionally infirm and does not impute, unless it's a government agency or law enforcement agency, a duty for the state to go out and affirmatively collect things that a layperson has, especially when the defense has the same subpoena power.
I agree that the state does not have an affirmative obligation under the statutory regime. I agree with the state that the absence of the obligation is not constitutionally deficient for exactly the reason Mr. Hughey just identified, which is that defendants enjoy the same subpoena power as does the state and are able to issue subpoenas for documents and records such as the one requested in this case. So motion 51 is denied.
And for what it's worth, we're just looking at that video with the pop-up bulletin. That's right. That's like seconds from the end. We can just trim the thing and it should be very easy.
Just end the video a couple seconds
I
early.
think so.
Okay,
Yeah.
all right. Motion 54 seeks to exclude, I think, the same video, and I think, again, related to the end where there's a pop-up that implicates, there's a up next pop-up that comes up with respect to Mr. Gibson. Can we solve that with the same issue
Very easy.
or the same solution?
Conceded, easy to do.
Okay, 54 is granted as unopposed, and the state is ordered to fix it.
Yeah, you're right. Covers them too.
I didn't think I saw that. I mean, I've seen versions of it.
I mean, that's just an easy thing.
No, before. The march on the Cider Riot.
Well, no, the motion.
That's before.
Folks ready to keep pushing, or do you want a minute? We're doing fine, if you need a minute.
No, we're good to keep going.
Okay, motion 55 seeks, specifically with respect to this potential witness, to enforce the same rule as it applies to other witnesses, and to prevent this witness from referring to any participants of the May 1st incident as a racist or as a fascist or a Nazi or other similar epithet.
No objection to that with the maybe unnecessary clarification that it be limited to trial testimony. Obviously, we can't, there's people shouting all sorts of things in the video. But if any of those people come to the witness stand, they can't say these things, we're fine with that.
Okay. Does that correctly cover the full scope of the motion?
Yes, Your Honor, witness testimony.
Okay. I agree. Motion eliminate 55 is granted as unopposed, and that will be the order. All parties are ordered and instructed to so admonish their witnesses. Next is motion eliminate 56.
And this
56.
This kind of line of motions is taken directly from what one of the officers, I think it was Detective Trainer, documented in his report. These are the beliefs of Mr. Sappy. This is what Mr. Sappy told me.
Okay. So 56 seeks to preclude this witness from testifying that it was his understanding that Mr. Gibson decided that the group would go over to Cider Riot. It's essentially the motion itself is grounded on relevance, prejudice, hearsay, and speculation or opinion. I'm reading it essentially as a foundation exhibit, or a foundation, sorry, it's been a long day, a foundation motion objection to this kind of testimony on the grounds that Mr. Salpe could not have known it.
Right.
There is no foundation for his own personal knowledge.
Yes.
And that's how we would encourage the court to rule on it, just to clarify that the court will enforce the requirement that any statement or exhibit be supported.
So that to the extent the motion eliminate is grounded in foundation, the motion is granted. This witness will not be allowed to give this testimony unless a sufficient foundation is first laid. If that foundation is laid, I think the testimony is relevant. I don't think it's unduly prejudicial, such that the undue prejudice substantially outweighs the probative value. And it's not really opinion testimony if it's something he knows. So the rest of 56 is denied. 56 is granted as to foundation, and the state will need to lay an appropriate foundation before
for seeking to elicit that testimony.
For seeking to elicit that testimony. Thank you. Give me just a moment. Try to break off in the middle there. Moving to motion 57. Essentially a hearsay objection seeking to preclude this witness from stating that he was told by a large older male with a pointy goatee that they're going over to Cider Riot to quote unquote start some shit.
Yeah, I don't, that's fine. We can see that.
Okay. Motion 56 is granted as unopposed.
That's 57.
And-
Yeah, 57.
As the court is reading the motion out loud, I hope that the court.
I'm sorry, that was 50. I said it was 56. That was 57.
I hope as the court's ruling is understood to be not so confined that if he says it was somebody who didn't have a pointy goatee.
Testimony of that kind,
Yes.
even if the particular details are slightly different, is excluded pursuant to the court's ruling. Motion 58 is, I think, of a similar, it's coming from a similar place as 57.
Yeah, I think as it's written, it's sort of a demonstration of an absence of proper foundation. So no objection to the court granting that motion subject to.
Well, I think there's a hearsay. I think there's a hearsay exception. I'm sorry. I think there's a hearsay objection. Boy, I'm having trouble. It's been a long day. With respect to motion 58, I think there's a hearsay objection that is really grounding motion 58.
Right. I guess, yeah, that wasn't super clear the way I said that. When I say foundation, right, the way this is hypothetically drafted is it suggests a hearsay problem.
Right.
That's fine.
Okay, motion 58 is granted as unopposed. I understand, I think where Mr. Hughey was going is this witness may have personal knowledge on the same topic. This motion doesn't seek to reach so far. Motion 59 seeks to preclude the introduction of testimony from this witness that as the group walked towards Cider Riot, it became clear to this witness from the chatter amongst the group members that the group was going there to quote unquote start some shit.
Yeah. Yeah. I think, Your Honor, that we do oppose this in, not the exact phrase to start some shit, but just that he should be allowed to explain why he started filming because it seemed like there was about to be a conflict or something like that. Does that make sense?
So as opposed to, so are you distinguishing between him saying, I overheard this thing versus his lay opinion that this was his understanding of what was going to be going down?
Lay opinion that may be formed by a statement that is not offered for the truth that it asserts that shaped that lay opinion, right?
Right, okay. So Mr. Lee, there's a distinguishing here between what Mr. Saupe believed and things that he heard. And the way the motion is written, it sort of joins those two things. It objects to his saying that it became clear to him because of what was being said. The what was being said is obviously out. But the question is, what about his lay opinion about what was going to happen?
I hear the state is saying they want to introduce still what he heard as far as people saying they wanted to start.
Oh, I'm sorry, for some purpose other than the truth? Thank you.
Right. As to why he's thinking,
But that really is offering it for its truth. That is to say, if he has an opinion based on his observations, that may be an appropriate lay opinion. But if your question is, well, what did you hear that made you think that? or if your question is more neutral, what made you think that? And his answer is, well, I was hearing all this stuff. I think at that point,
Yeah, I think it's easily avoided and we're fine.
okay, so I'm going to grant the motion insofar as it relates to no description of things he heard, but he can give his lay opinion. If there's a foundation objection, then we may be opening the door to those things.
He can give his lay opinion as to what?
As to what he thought was going to happen when they all got there.
And I would propose that he could also then say, well, was that, I don't want to ask you what they were. Was that based on sort of the chatter you were hearing? Yes, we're moving on. Not going into any actual statements.
That's problematical.
What's interesting about this is that these videos were extensively used by people of Mr. Allen's persuasion. He was an undercover agent working for Antifa who was out there filming and seeking direction from his handlers as to what to film, specifically attempting to provoke commentary about Gibson. He reported to Cider Riot at the end of his filming to deliver the filming, and they sued Mr. Gibson 2 days later. Other people have viewed this footage. There was an article in Reason magazine where they viewed the footage and said, you know, you can't infer anything about some preparation for something from this. And so if they're entitled to put on a witness like Mr. Allen who says, well, I saw this, heard all this chatter and concluded this, we can have 10 other people watch the video and say, well, I've listened to the chatter and we don't think it means that, and we don't think it means that. It's not under Rule 701. It's not really helpful to the determination of a fact in the case.
Well, so this is Mr. Souede, it's not Mr. Allen.
I'm sorry, Mr. Souede.
That's okay. I think the question is less, well, the initial question is whether this witness's lay opinion is relevant. It is relevant. It may also be prejudicial, but it is relevant. And then the question is, can he explain to the jury why he came to the opinion? You all know the evidence better than I do. Is Mr. Souede in a group with Mr. Gibson or with Mr. Lewis or with Mr. Schultz?
I don't expect him to testify as in a group with any of them. I expect him to testify that he's just interested in what's happening and he hadn't been here very long and wanted to film it.
But when he's hearing chatter, is he going to testify that he heard chatter that involves any defendant? Give me just a second, Mr. Lee.
Judge, I believe that his testimony would be that he heard the chatter that there was going to be something happening there, and I don't, unlike Mr. Allen, who's associating with folks who were associating with Mr. Gibson in some way, shape, or form, I don't believe Mr. Souede was, but I'd have to double check that.
So here's the problem then, is we have a witness who, I mean, I understand Mr. Lee pulled the language from the police report, and so this is this witness's opinion about what was going on, which is perfectly appropriate for a police report. But what we have then is a witness who is around people he doesn't know who forms an opinion about what those people are going to go do. And so when I said a moment ago that lay opinion is relevant, well, with that understanding, why is that lay opinion relevant? That he was with some other group of some other people and had an opinion about what those people were looking to do when they got there because of what those people were saying. Why does that have a bearing on this case?
To the extent it explains why he goes over there and starts filming or continues filming and recording.
Okay, no. I'm going to grant motion 59. I think 60 is of the same moment, but I'll give the state another run at it if they want to.
No, I think I would be repeating all the same arguments.
Okay,
Essentially the same.
I'll accept the same arguments from the state for the sake of the record. Motion eliminate 60 is granted.
61 is also very similar.
Yeah, I don't think there's a distinction, really, a meaningful distinction either.
I understand this is opposed as well for all the same reasons the state has already explained, and for the same reasons that I have explained, motion 61 is granted. Motion 62 seeks to prevent the introduction of testimony through this witness
Very similar, Your Honor.
62, it's a little nuanced, but it looks largely the same.
Yeah, I'm not sure I appreciate a distinction. If I do later think there's some distinction, I'll of course raise it with the court ahead of time.
Otherwise, I'll grant this motion over the state's objection. And finally, motion to eliminate 63. This, I
We
think we
might have
already
already
covered.
addressed this.
I think we already covered this.
I withdrawn. I know we already covered this and got a ruling on it. So
Okay. Motion to eliminate 63 is withdrawn. Any additional oral motions at this time on behalf of Mr. Gibson?
Just,
Gibson.
oh, I'm sorry.
not an oral motion, an issue I wanted to advise the court of.
Okay, could we put a pin in it and
Yep.
we'll let you, but I promise we'll make time to get back to it. Thank you, Mr. Lee. Mr. Schmuntz, any motion at this time?
No, Your Honor.
Mr. Doyle?
No, Your Honor.
Thank you. I believe I'd heard from the state that it had a couple of motions to eliminate. I think we might have satisfied one of them already.
Wait, on the way through.
Maybe not, but I'm happy to hear any such motion.
Could I just briefly return to the 59 through 62 series?
Yes.
I just want to, we want
okay.
to kind of understand the framework of just asking Mr. Sape something kind of innocuous like, why'd you go over there? Why were you filming? It seems to me that he should be able to say, I thought there might be a conflict, as generally as that, but not attribute it to.
Okay, a very fair point. Would there be an objection to that question and answer?
Oh, Jeff.
Yeah, I don't think it's necessary, and I think he could easily answer truthfully. Well, and by the way, I would note, he turned his video on before they got to Cider Riot. It was on for a while. And I think he can very clearly say, well, there was some interesting stuff going on. I wanted to see what was going on. There's a lot of things going on. I wanted to film it. What is...
As opposed to using the word, it's the word conflict that
Yeah,
raises your
and
hackles.
that's got no...
Mr. Schmuntz, did you want to be heard on that?
I agree with Mr. Lee. There's no reason to. The jury doesn't need to know why he's filming. He's filming. So what? Lots of people are filming. There's going to be so many different videos in this case.
And if I may, Judge, I'm trying to not have two
It's
different
okay.
people talking,
It's all right.
but it goes to his credibility. Mr. Buchal just accused one of the folks filming of being some vast underground conspiracy where he's got a handle and everything else, and he needs to be able to say why he went there. And if that's the reason, then let that come out. But the reason, I don't believe he's just going to say he's interested and he was filming there because he thought there might be some sort of conflict, and that's why he was where he was filming. He doesn't have to get into details.
If we opened the door and said he was working for Cider Riot to frame Joey Gibson, then I think it would be fair to do that.
I understand. We're gonna be very. I am gonna be very lawyerly here. The state's fundamental point is well taken, which is that in order to have any credibility, this witness has to be able to truthfully explain why he was doing what he was doing, or in order to potentially have credibility. That doesn't make him credible, but that's the only fair way to allow a jury to assess his credibility. The word conflict has a number of potential meanings, some of which suggest sort of a violent tumult, and some of which do not. So I do not like the word conflict, because I agree it is pregnant with some potential unfair and undue interpretation. If he wants to say that he knew that there were going to be groups who disagree with each other there, and then it might be interesting to watch, I think that's fine.
Something film-worthy, anything, I don't know.
If he wants to say it's film-worthy, I think that's fine. The word conflict is out. Other words that come laden with potentially violent understandings are out. This might be best done if we can agree to some leading questions and agree to the language ahead of time. My ruling for now is, yes, he can provide an explanation for why he was there. But no, that explanation cannot use a word such as conflict, which suggests some kind of actual physical confrontation.
Understood, Judge. I'll try to get a hold of him ahead of time so that I can have some more details and craft some leading instructions that'll satisfy my defense.
Okay.
Sorry. All right.
Additional motions in limine from the state.
The state has a couple, Your Honor. The first is kind of at the core of what we've been litigating and arguing about for quite a while, is to exclude from this trial the defense eliciting or seeking to elicit evidence, and then the accompanying motion, of course, is to also exclude argument of some being charged or prosecuted and others not. And how I envision that is asking a detective or anybody, well, Did you charge that person? Did you charge that person? Why weren't they? Why weren't they? And then the same kind of argument. Why wasn't this person here? Why wasn't this person here? I'm looking at the elements to riot from the pattern jury instruction. It doesn't make any of those material facts more or less likely. Same thing with credibility in the state's view.
Okay, thank you.
As a starting point, Your Honor, I would note that we went through the effort of putting our motions in limine in writing, legal authority, so that the other time would have opportunity to respond.
If you would like some time to respond, that's fine. Oh, I'm happy to take it up tomorrow
Yeah,
morning. Okay,
yeah.
maybe what let's do is let's have the state utter its oral motions, and we'll give the defendants till tomorrow. If you want to craft something in writing, that's fine. If you just want time to prepare an oral response, that's fine. But that's fine. We can do it that way.
The second is just to exclude the OLCC report. It's hearsay and irrelevant.
So they have two motions in limine, and could you restate the first one so that we all know what we're actually working with for a motion?
Well,
Can I repeat it to make sure I
Please,
understand it?
yeah.
I understood the first motion to be directed at no asking questions or attempt to admit evidence or argument to the jury relating to any alleged selective arrest or selective prosecution.
that's well put.
Second one, simple enough, simply to exclude the relevant OLCC report.
Were you going to Mr. Kalbaugh or the state, Mr. Hughey, going to address the grand jury testimony?
Oh, that's the third one.
You have a third motion.
Yeah, we weren't done yet. We were.
Okay, I thought it was just two.
I thought it was just two also.
No.
Okay.
I think he wanted a grand jury transcript. I think I emailed you in response.
Right,
to that.
and
Yep. So defense had said that they wish to offer the grand jury transcript as an exhibit for impeachment evidence, and we'd be objecting to that. There's no authority that's been cited that says they get to do that.
Okay, so that's your third motion, is to exclude grand jury transcript as an exhibit.
Yep. And obviously there's a statutory framework for how to go about impeaching someone with prior statements or with prior sworn testimony, but simply admitting the transcript is not it.
Okay, and your understanding, well, I'll ask. The intent would be to use the transcript purely for impeachment.
Yes, Your Honor.
Okay, all right. We will take up those three motions tomorrow morning.
The last one we had, Judge, last one.
And we will also take up.
As a general, I think this is common, but just, we provided an exhibit list. We've got an exhibit list from some defense counsel, not others. We've got opening statements coming up. The state always asks if defense counsel intends in an opening to publish exhibits that they expect to be offered. Since we don't know what those would be, we ask the courtesy of being able to see those ahead of time to avoid a mistrial.
So we were going to talk about that anyway ahead of opening. I'll just tell you what my policy is.
Thank you.
Which is any piece of evidence and any evidence or any demonstrative that is intended to be used, that you intend to use for opening, needs to be shared with the other side with enough time to bring it to the court's attention before it is used. If things are pre-admitted, I assume there will be no objection, but everything else needs to be shown to the other side so that any dispute can be brought to the court before it is shown to the jury in opening.
We can, on behalf of Gibson, we can announce now, if that helps.
Sure.
I'd like to see it too, but yeah.
Well, there's your videos on your exhibit list. We're going to present portions of those, and then the other portions of the other video that Mr. Buchal sent you just the last couple of days or two.
Why don't I propose we revisit this after we talk about redactions and trimming tomorrow.
That's fine,
Okay.
but but the conferral part is helpful.
Oh, absolutely.
So it doesn't have to involve me, but
Yeah.
And it was for everyone, not just Mr. Gibson, anyone else. We just want to make sure we don't
no
have
one
any
gets
random
to
objections.
no one gets to show anything until the other side has either agreed or it's come to me for a ruling, and I say it's okay.
Yeah.
Anything else for the record today?
Not from us.
No.
Off the record.
Okay, we are,
Off the record.
hold on.
Oh, Mr. Lee, you had an item. Was that for the record?
We're
It
off,
was the grand jury testimony
Perfect.
issue.
Okay.
we're off, so,
Nope.
okay, perfect, just.
Anyone want to?
Okay, so I know they said they're off the record and all that, but after they went off the record last time, they kind of snuck that one in on me when I thought they were done. So I'm just going to wait a minute because they should turn off WebEx since it's the end of the day, and yeah, he's definitely peaking, and that's why I wish I could separate his mic from everyone else's, because I have to boost theirs just to get in the mid-range. So it's either I get a good volume for him and can't hear anyone else, or he peaks to hear other people. Probably won't be as bad once we get to trial, because at that point he doesn't do much talking, it's just the judges. Okay, we have officially shut down the live stream from the courthouse, so yeah, it sounds like there will be motions sometime tomorrow. I'm not sure yet what time, probably 9 a.m. I'll try to see if I can get confirmation from the court. I've already emailed. I don't know if I'll hear back tonight or not, but anyway, I will otherwise plan to be set up to stream 9 a.m. tomorrow. Come on back if you've got the time. If not, we've got Monday to for the actual trial to start. Gray Mouse. I'm not sure what you meant by Gray Mouse. Yeah, apparently they did that the day that he got indicted. They had an event scheduled where they did 7 laps before and after his indictment, but that was the Justice Center, and for what it's worth, it's still standing. But yeah, I fully suspect Monday morning I'll be saying I wish it was Sunday. Yep, not a problem. Oh, hey, Rev. Yeah, I'll talk to you on Discord in a few, Rev. Everybody take care. Be safe. We'll see you later.